Good afternoon, ladies and gentlemen, and thank you for joining us. As you are aware, every Thursday between 4 p.m. and 5 p.m., the South African Bar Association hosts a speaker to deal with a legal topic intended to assist young practitioners with training and development, which feeds into the core values that we hold as an organization. Before I introduce today's speaker, I pause to reflect on those that have been suffering by what is now known as the third wave of the COVID-19 pandemic. We have all lost family, friends, and colleagues, and I deem it necessary to offer a short moment of silence for prayers and meditation in lieu of such loss. I am certain that we will prevail. Today's speaker is no stranger to us, in a sense that he has been a practicing advocate since 2007 and an acting judge of the North Gauteng High Court. His career in teaching law spanned over 20 years in legal practice. Notwithstanding his academic knowledge, he holds, amongst others, a master's in commercial law, a PhD in drafting and interpretation of contracts, a PhD in corporate governance, a PGC in Introduction to Corporate Law and Governance from the London School of Economics, a PGC in Prospecting and Mining Law from the University of the Witwatersrand, and a PGC in Corporate Governance from the University of Cape Town. He is the legal expert for various news stations, such as SABC News, Newsroom Africa, ETV, SAFM, Fela FM, Vanda FM, amongst others. What is of significant importance is that during his address on these various news networks, he has the ability of breaking down the law and explaining it in a manner which is understandable to all persons. Of particular importance for Vanda FM, for example, he breaks down the law in the native language so that the majority of the nation can understand. It brings me great pleasure in introducing today's speaker. Acting Judge Romeo Nthambeleni will be speaking about the simplicity in drafting. I have the honor of knowing Romeo as a personal friend, and albeit His Excellency, he is one of the most humblest counsels I've ever met. He is always willing to assist. He is transformative and indeed a valued member of the South African Bar Association, who has and will continue to work very closely with. I must confess that when I was with Romeo last night, I asked him, amongst other things, as to how he is so precise and coordinated within his judgments, and his response was, the name of the game is narrowing down the important issues, which I am hoping he will share such legal craft with us today. In terms of housekeeping, during Romeo's address, all participants shall be muted. Should any participant have a question, you can either raise your hand, whereby you shall be unmuted during the question and answer session. Alternatively, you may type your question within the chat box, and such question shall be put to Romeo after his address. With much further ado, I now introduce you to Acting Judge Romeo Nthambeleni. Romeo. Romeo.
Yes, thank you very much, Ahmed. Can you hear me?
I can hear you now. Thanks.
Oh, thank you. Thank you so much. Thank you very well. Thank you so much for that wonderful introduction. And like I was saying that for a moment, I thought you were not speaking about me there at the moment. So thank you. I think we need to get this show on the road. And there's a person who's appearing on the video there who's eating. Can you just request them to close their video there and first finish their food, and then they can. Yes, thank you very much. Thank you, Ahmed, and good afternoon to everyone and the participants. And I thank you once again for being presented with the opportunity to present this afternoon. It's a great honor for me to be presenting. Thanks. So let's start by drafting pleadings 101. I start by saying that great lawyers draft in plain language. Bad lawyers draft as though it's still 1800. What I'm saying there is what is important is that the use of plain English in legal drafting is very much important, and it opens legal doors. It is important that the message in the pleadings is delivered in a proper and plain language. The days of legal jargons are over, and we are moving into the future where the legal principles must be brought down and enunciated in a language that ordinary people will understand. Yes, maybe 10, 20 years ago, it will be flamboyant for you to present in Latin and use big legal jargons maybe among the colleagues. But in this day and age, it is completely becoming unfashionable to be using big legal jargons and talking in a language that people don't actually understand. Then the principle is that legal writing in South Africa and in the world at large must be simple, and it must be straightforward. In South Africa, it must promote the spirit of the Constitution of the Republic of South Africa and the Bill of Rights, which promote equality and equal access to justice for all. So we cannot talk about equal justice to and access to all without actually bringing down the law in a language and a manner that everyone will understand. So it's quite important that we need to emphasize this to lawyers that the more simple the language, the more accessible the legal issues will be understood by ordinary people. Let's start with the style and layout of pleadings. The court requires that the guidelines practitioners use Arial 12.5. That's a standard typing with double spacing. So it's quite important that practitioners follow that font language and the style. And we have seen so many different fancy footworks on the papers that are brought before the court, which don't comply with the requirements of the practice directives of court. So that is completely discouraged. There are further guidelines in relation to the format of alignments that are prescribed in terms of the practice directives of various divisions. Please stick to the guidelines and don't, as I said, don't use fancy footwork and strange language of typing styles that overlap and are over imposing. And I'm repeating this again. The use of Latin should only be restricted when it is necessary. It does not impress the judges and it does not win you a case. In law, you are as good as your facts. If you don't have good facts and you don't have good grounds and good principles in law, you don't have a good case. So it doesn't matter how much Latin you want to throw at people. It doesn't win you a case at all. And then what are perhaps the objectives of the pleadings? In court, we say the following, that with pleadings, you stand and fall by your papers. It means that the object of the pleadings is to define the issues and the parties, and the parties will be kept strictly to their pleas, where any departure will cause prejudice or will prevent full inquiry. But within those limits, the court has a wide discretion, for pleadings are made for the court and not the court for pleadings. And where a party has had the facility to place all the facts before the trial court and investigation into all circumstances has been thoroughly done and patient in the instance, there is no justification for inference by an appellate tribunal merely because the pleadings of the opponent has not been eclipsed as it might have been. This is the quotation from Ines CJ in Robinson versus Randfontein estate, and it sums up the importance of the pleadings and the message that they are supposed to deliver. So you must make sure that your pleadings will not cause prejudice or will prevent a full inquiry and the ventilation of the matters that are supposed to be before court. So the language must be clear, it must be precise, it must be concise. And then what are the ingredients and recipe for good pleadings? It's very, very much important for lawyers to have basic knowledge of the applicable law and the facts. And then the clear knowledge of the rules and the practice directives of the divisions where the practitioners are practicing from, cannot be overemphasized. It's important that practitioners familiarize themselves with the practice directives and the rules of court where they practice. Always say here that you must know the rules, and the rules will set you free. Avoid precedents at all costs, because they become costly in the long term. In precedents, when you have copied the precedents and you have pasted them to your documentations, you have a very good chance of speaking about horses where you're not supposed to be talking about horses, and you're going to be caught out because of the irrelevant paragraphs that will be contained in your pleadings. Because as I've indicated, that these cases differ, and your cases might look like it's the same case with another person's case, but when you look into the facts and you make investigations, you find that there are material differences in terms of the principles that are supposed to be applied. Develop your own method and style of writing and structure of your pleadings that are tailored to your case. That's what is very much important. The pleading is there to guide you, but it's not something that you should be married to, because your marriage to pleadings will have an unhappy ending. I just want to warn you on that. We have seen many practitioners and counsellors who have copied pleadings, and when they appear before court, we start asking them that there's a name of this person that is appearing. What is happening? And then you'll realize that no, I was given a precedent by another colleague and I was using their precedent and I forgot to omit their name. A pleading should ordinarily set forth the law, set forth neither the law nor the evidence. Pleadings are generally divided into two principal concept: allegations of fact and the conclusions on the law flowing from the set of facts. So that is an important aspect that you need to look at. The issue of fencing, there's an issue that is colloquially referred as fencing in the pleadings, wherein fencing is when the pleading is too cautiously drawn to avoid exceptions. You find that you are told that you need to be very much careful when you draft, so that your pleadings will not be executable. Nobody wants to have pleadings that are executable. So the dangers of fencing is that the pleadings may be so cautiously drawn as to avoid exception, or either disclosing, they end up not being able to disclose of course of action, or no defense, as the case may be, or even becoming vague and embarrassing in that process of trying to avoid exception. So the matters withheld in the latest, you find yourself that you have to come to the very same issues that you have been avoiding. So it's quite a challenge that you find that the things that you were trying to answer and the things that you were trying to avoid, saying you don't want to address these issues, they are coming back at a later stage. And if the court picks it that there was a difference, the delay effort of fencing for technical reason, an amendment that might have been granted might be refused on that basis, that you have cornered yourself, and you have thrown yourself in the deep end, and you are failing to come back, and the coming back to actually hit you. So technical advantage sort may backfire, as it happens many times in practice, and you will be an amendment, and unfortunately under those circumstances, find that your client's case is affected or jeopardized. So that is the position in relating to the pleading. And then pleadings that are drafted by counsel. There's a reason why legal drafting for advocates examination is 5 hours. Good legal drafting is key to a successful career as a practicing advocate. Generally, attorneys expect advocates to be good in drafting and trial advocacy, and these are emphasized in training of trainings of advocates. Attorneys that don't prefer appearing in court, who prefer drafting counsel. They expect their counsels to be good in drafting papers and also in trial advocates. So it is also true, and it's also a fact that you might have experienced that not all advocates are extraordinary orators, but however, your lack of vocal abilities in terms of presentation in court may be redeemed by well drafted pleadings. Is very, very much important. We have seen on many occasions appearing with opponents and people appearing in court that a person might not really per se be an excellent orator, but in terms of the papers and the pleadings that have been drafted, the papers speak for them than their own voices. And then pleadings are supposed to be couched in a manner that even when you have a case against the devil, your papers, the way that are couched, the devil will say to you, I've read your papers and I want to offer a settlement in this matter because of the nature of your papers and how they are actually drafted. I was trained by a mentor who had a reputation of being an excellent draftman in terms of the pleadings. This is what used to happen when we appear together in court. In all my appearances, when I was appearing with my mentor, the moment my mentor appears in court, there's two things that were going to happen. The court was either going to make these remarks: we have read your papers, you may kindly give us an opportunity to allow your opponent to address us. And then the court will take 30 minutes grilling out the opponent that is appearing on their papers. And when they're done with grilling the opponent, they will say to my mentor, we have read your papers. Can you please hand up the copies of your draft order to be made an order of court? And those draft orders will be handed up. Therefore, I'm trying to show you that it's important to earn a good reputation in practice than to earn a bad boy name tag that you are known for bad pleadings, and it defines your practice. And then when it becomes like that, that kind of name defies your practice as well, and you will be known for bad drafted pleadings. So avoid bad drafting at all costs. That is what is very, very, very much important. It's important that when you draft your pleadings, you check them, you revisit them, and you assess them, and you check whether your pleadings are married to the facts and the laws and the law as presented. Don't rush the pleadings. My mentor will take several days working on pleadings and correcting himself and working on them and correcting himself. And when I was asking him the questions, he will tell me, this is the reason why I want to make sure that the papers are drafted properly and the papers will be able to speak for me when I appear in court. And I've seen that working. So the standard pleadings that we are requested to draft most of the time is particulars of claim, plea admissions, special pleas, replications, exceptions, denial, confessions, and avoidance. And and non-admissions. Those are standard pleadings that we are from time to time required to draft. Then let's talk to attorneys' instructions now. Attorneys from time to time give us instructions to settle their letters. I wanted to read out a letter for you, which was drafted by an attorney, but unfortunately I don't have this letter present at hand. When I read the letter, even myself, I called my attorney and I asked him, what were you writing here in this letter? And it sounded like it's old Shakespearean English mixed with the Roman Dutch law. I couldn't make sense of the letter, and I could just pity the audience that was going to actually read that letter. And there was a lot of panel beating that needed to be done on that letter. What I did was to completely restructure the letter and bring it down to earth, and bring it down to 2019, the year that we were in, and corrected everything and reshaped it and repackaged it so that I can be able to send it back, because I wouldn't want to be associated with that kind of language that is written. Now, even when you are sitting reading that letter with the dictionary, some of those words you are not going to be able to find on the dictionary. So letters, advice on evidence, memorandums, and then sometimes you are requested to draft agent applications. You are requested to draft opinions and affidavits and answering affidavits or replying affidavits. So with opinions, it's very much important that counsels must be aware that writing an opinion that you are writing must be based on the law. It must not be based on the feelings of your attorney and the clients. The opinions that are written, please, clients and attorneys which are not sound in law, they get overturned very quickly, and they are taken to court, and you will find that it becomes problematic, and your name is against that opinion. So when you are writing an opinion, make sure that that opinion complies with the requirements of the law. It's not written with a mission to please the people that are giving you, instructions. And then now I deal with case studies that happens in court. I'm going to deal with case studies maybe up until 1:30, and then I'll ask that if there are questions, then we can field and then have a proper discussion from 1:30. So the case studies that happens in court is, in my experience now acting, I've witnessed many cases where junior counsels are appearing against senior counsels. And when I'm talking senior counsels, I'm not talking just new senior counsels that are having over 10 years of experience in practice with baby juniors. And the matter that is before court is that when the juniors are appearing, and the juniors have got very good case on their facts and the law, and they are well prepared for their matters, and they argue and they argue and they argue like the matters that I was listening to. You find that at the end of the day, in one of the matters, the way the junior counsel argued so well, when we were supposed to make an order, the senior counsel saw that there was a very serious issue and he was not going to be successful with the case, and the order would be against him. What happened was that the matter was stood down, and when it was stood down, I was told that no, we will come back. And then when I was waiting for them to come back to proceed and finalize the closing arguments, I was told no, we have settled the matter, and then we are going to ask that the draft order be made an order of court. And then the senior counsel considered the matter and then also tendered the cost. So I'm trying to show you that it doesn't matter in terms of the kind of experience that you have in practice. Where once you have a bad case, You can call signatories to come and appear in that matter. You're not going to be successful because you don't have a good case. It's not about the name that you have. Then you find that you don't have good facts and you are just huffing and puffing. You have to deal with this situation. No, and I have also dealt with these situations in court where I've witnessed counsels that were being embarrassed due to the papers that were not drafted by themselves. It's one thing where you have drafted the papers yourself. You can own up to your own mess and say, with this kind of experience, I'll be able to learn going forward. But they were instructed either by attorneys who either drafted the papers themselves, or they've instructed someone else that was not available to be present in court to actually move those papers. And you find yourself standing in front of the court, in front of your colleagues with those kind of papers, and you have to move them, and when that kind of situation arises, and 99% of the time, where counsels are being asked about the status of their papers, and they have instructing attorneys. The instructing attorneys have a tendency of vanishing into the thin air, like the three witches in Macbeth. You will never find them. They bury their heads in the sand, like the ostriches. So the best thing that you need to do is to verify the status of your papers before you appear. And while you're appearing before the court, the judges are not going to be forgiving that you're not the ones that you're drafting the papers, but you are the one that is moving the papers. It's like when you are driving a car and you have exceeded the speed limit. You're not saying that, you're not going to tell the traffic officer that the car does not belong to you, it has been borrowed. You are the one who is sitting on the driving seat and you must be in charge. So it's very important for counsel to inspect the status of their papers before they proceed and appear in court, and stand up and say they appear in the matter and they the papers are in order and they want to move for orders that they are praying for. So that is very, very much important, and I think I really needed to say it very clearly. Yes, Ahmed.
Thank you, Romeo. Thank you for that address. We have a question from Advocate Bart Ford.
Yeah.
Good afternoon, Judge.
Good afternoon, Bart.
Judge, tell me, when you draft heads of argument, is it important to have the heads of argument written in a first or third person? Often when you read heads of argument, it almost comes across as the person is deposing, as opposed to dealing with heads of arguments in the third person. That's the first question. The second question is, there are certain standard terms that we find in affidavits, like the facts herein are both true and correct, and unless otherwise indicated. I want to know, as a judge, does the judge even care about those type of statements, such as to the extent where I make references to legal authority, such as done on the advice of my legal representatives, whose advice I verily and truly believe to be true?
Yeah, no, but thank you very much for
Romeo, your mic is muted, eh?
Is it fine now?
It's fine now. Sorry, we didn't. Can you please repeat your answer again? Sorry.
Okay, thanks. I started by saying that I'm going to deal with the heads of arguments separately, and I'll answer that question in relation to the heads. I've got the section that we are going to look at dealing with heads. And in terms of affidavits, what Bart Ford was saying, it's very, very important. When we are reading affidavits, we're not looking at that. We are not looking at whether you want to say, I verily believe the advice that has been written, and that is completely unnecessary. And I think we really have to re-emphasize that it doesn't change the the price of bread at all. And an affidavit must just be done properly. It must be commissioned. It must have facts that are relevant to the case that is before court. And that is very, very much important. To say that the legal advice that has been given is I know and is very true. It's something that is a bad tendency that people got used to. And it's about time that we start. We need to start developing a new proper way of drafting, that avoids repetitive words. And what Bartford has just indicated there is the superfluity of the papers, because you just repeat yourself and then it becomes verbose, and it's a reputation that is completely unnecessary. We don't look at that, and I don't think it's really necessary.
If there's any other questions, you can kindly, I've allowed for everyone to unmute their mics, so you can ask Judge Romeo any questions that you'd like.
Okay, then let me proceed.
The only thing that remains for us is to thank you, Romeo, for your time. As I have indicated earlier, Romeo is indeed a valued member of the South African Bar Association. Appreciation goes out to those that have attended virtually. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. Before I end, just give me 1 second, Romeo. Sorry, just give me 1 second.
Are we ending now, or are we ending at 5?
No. Just give me 1 second. I think there's questions. Just give me 1 second.
Yes, I've got a question.
Yeah.
Hello?
Yes. Go ahead. We can hear you.
Yes, you can hear me.
Yes.
Yes. Judge, can you actually come? I didn't pick you well when you're talking about saying avoid fencing. Well, what is exactly that you're trying to, where you emphasize it?
Okay, I'll go back to it now and tell you exactly what I was talking about when I was talking about fencing. It is about the style of pleadings. I'm going to go back to to it now and explain to you. Fencing is when the pleading is too cautiously drawn to avoid exceptions. So you sit with your pleadings and you say, you know what, I want to draft these papers in a way that I'm going to avoid having an exception, or making my pleadings to be executable. So the danger is that the pleading may be too cautiously drawn as to be to open yourself again for an exception when you are trying to avoid it, by either disclosing no cause of action, one, or no defense, as the case may be, or even becoming vague and embarrassing because you're too careful. You want to cover your ground too much, and then the matters that are withheld, and where the fencing that you are trying to do, to say, I don't want to disclose this because this might be used against me, or I don't want to disclose that because this may have an adverse impact on my case, will then catch up with you at a later stage. So that's why we were talking about fencing, to say you may have a problem of encountering the very same things that you wanted to fence yourself against. And if we pick it up at court that there is an issue relating to you trying to do deliberate fencing for technical reasons, you might be refused an amendment at a later stage, which might have been a valid amendment if your pleadings were properly drafted. And then that technical advantage that you were seeking for yourself, we might actually come back to backfire against you. I hope it answers the question.
Thank you very much.
Yes.
Romeo, there's a question on the chat box. Judge, please repeat the case reference for pleadings. This is the Randfontein case.
Okay, the Randfontein case, I'll give you the citation again. It's Robinson versus Randfontein Estate, GM CO Ltd.
Thank you. There's another question. Good afternoon, Judge. What is the most prevalent mistake you have seen regarding the drafting of Baby Junior's pleadings? Do you have any advice for us?
Yeah, no, it's general. With Baby Juniors, you can see that it's hastily drafted papers that are done without looking at the law, the applicability of the law and the facts. So it's very much important that you have the understanding of the law and the facts, and you are able to marry the two. And another common mistake that Baby Juniors are doing is not understanding the rules and their applicability. And then if you do that, if you understand the rules and their applicability, and also be able to comply with the practice directive of the division, that will actually help you quite a lot.
There's another question, Romeo. Thank you for that. There's another question. What is the difference between concise heads of arguments and main heads of arguments?
Yes, I'm going to go to the heads of arguments. I will deal with the heads of arguments in the next session that I'm looking at here, and I'll explain what the structure of heads of arguments and how they are supposed to be dealt with, because Bart also asked the question on heads of arguments, and I've got a section that deals with the heads of arguments, which we're going to look at now. Can I proceed now?
Please do, Romeo.
Okay, thank you. Let's look at motion proceedings and applications. In motion proceedings, it's important that counsel is 100% sure that the papers are in order before you are accepting the briefs. To make submissions to the judge that the papers are in order when they are not is equally misleading the court. So there are a lot of matters that we are sitting with in motion courts. Like today, there was a roll with 50 matters on that I was listening to in motion court. So you can imagine the volume of papers that the judge has to go through, and different counsels that will be presenting. So various matters that are on motion court have different and various statutory requirements that ought to be complied with before the order is granted. Make sure that you understand those statutory requirements, and to allege that there is compliance with the statutory requirements when there is none might lead to counsel being embarrassed in court, and it's very bad. You will earn a reputation of misleading the court, and in the worst case scenario, if you develop a tendency of doing that, you might end up having to be reported for misleading the court because you are an officer of the court. And then applications and motions continue to if you have that kind of a challenge, that you find that your motion does not comply with the statutory requirements, it's better to remove your matter from draw and make sure that you fix the problems that are existing, and then bring your matter back. And then on agency, it is important to make a proper determination of the agency of the matter than to go to court on an agent basis and then you are hit with a court order that your matter is not urgent. And then again on affidavits, you make sure that the affidavits that are coming before court are properly commissioned, and then and that will help you to avoid unnecessary problems. In procedure and motions rule 6.1 of the Uniform Rules of Court provides that the application is supposed to be brought on notice and supported by affidavits, except only in petitions. So in this room hire is a proper local classicus for guidelines to determination whether you have to proceed by application as opposed to action. So it's important to also remember that claims for damages and also matrimonial matters are not suited for application. and because they normally carry a dispute effect that the room hire deals with. And then in some other instances, you might be lucky to find a judge saying that the matter is being referred to viva voce evidence for hearing. And in other instances, your matter will be struck off from the roll with an adverse order of cost against you. So preparation is important. We can never overemphasize the importance of preparation. Lack of preparation create problems for you. It can only end in tears. Please read your brief before you open your mouth and make submissions to court. That's one thing which we have picked up with baby juniors, that sometimes a person opens their mouth in court and make positive submissions without having read their briefs. And when they are referred to the relevant parts of their briefs where there are problems, they are seeing it for the very first time, and it shows that they have not read the papers. And as I've said previously, make sure that a proper case is made out for prayers that you're sought, or else remove your matter from the roll. And issues of service are very much important. Check the issue of service. Service is a big issue. The legal authorities to support your propositions. Affidavits must be served and filed with state officials where it is necessary, and then those drafts must be uploaded on case lines in time. And when you have not done it in time, as what has appeared in the matter which was before me in this afternoon today, please prepare an affidavit and indicate the reasons of your lateness, why you could not file the master certificate perhaps in time, the magistrate certificate in time, and then ask the court to condone your late filing of the matter, rather than sneaking it on case lines in the last minute, because you are going to have your matter being struck from the roll. So time is of an essence in the opposed application. So it is important that opposing parties talk to each other before appearances. There has been many occasions where you find that counsels are starting to speak with each other for the very first time when they are in court. So more time is wasted on short adjournments that are completely unwarranted and unnecessary to allow counsels to talk to each other during opposed motion proceedings. The court is always willing to accommodate unrepresented persons when they appear in court in person. It happens that in that kind of an instance where you've got an opponent who is a person who is an unrepresented litigant, it's something else as opposed where you have got a colleague that you could have connected to and have spoken to. And in case of amendments of draft orders, after making submissions in unopposed matters, it is important and practical to upload your amended draft orders so that the amended draft orders may then be made orders of the court. And then heads of arguments and practice notes. There are huge pitfalls in failure to comply with the practice directives relating to failure to submit practice notes in time as well. Practice directives have guidelines that are mandatory with regard to practice notes and joint practice notes that are supposed to be submitted by the parties. Practice note does not comply with the directives are simply not worth the paper that they are typed on. It's rather safe to get a standard a practice note and get assistance that is going to be able to help you and upload it properly and in time, not be, on the day where the matter is before court. Heads of arguments. Heads of arguments, the purpose of heads of arguments is to convince the court about the issues. This means that you need to address the issues that are succinct in your heads of arguments in terms of how you really want to deal with your matter. Well-drafted heads of arguments are important to assist the court. The judge might not even need to hear oral evidence if your heads of arguments are properly prepared and your submissions are carried properly in your heads of arguments. Don't be too long, as the heads of argument must be short and straight to the point. heads of arguments are not an academic paper, or a dissertation. Their aim is to assist the court to determine the issues, and they must have a structure. And then what is that structure of the heads of arguments? As a question which was asked by Bart earlier. The Supreme Court of Appeal rules regarding to lodging of heads of argument requires that there must be a clear distinction of heads of argument and written argument. The rule does not require or permit the latter. The operative word is the main heads of arguments. Main refers to the most important parts of the arguments. Head means points, not a dissertation, as I have said. Arguments involve a process of reasoning that must be set out in the heads. And in addition, to emphasize the point, the rule requires heads of argument to be clear, succinct, and without unnecessary elaboration and over elaboration. Some years ago, there was a matter in the tax court where one appellant's head was over 200 pages. And on the same point, there was the opposing counsel with less than 20 pages on the same matter. So you can see that when you don't necessarily summarize, you find yourself having to repeat yourself and repeating unnecessary arguments that are not supposed to be repeated. Typing is another issue. The rule, as I've indicated, is double spacing, not triple or quadruple. The font size is also important. And you have to stick to those frame and the structure. It helps with reading, because that's why you are required to follow a particular structure and the composition. The composition of the heads of arguments should have an introduction. They should have facts. It should have argument, and it should have the conclusion. And then when you have done it in that particular structure, you are going to avoid a situation of unnecessary or heads of arguments that don't have a structure. And in terms of styling, it depends from person to person on how the heads of arguments are written. Some write in the first word, as Bart has actually said, second. Some write as if they're addressing another person, but write it in relation to your case and your applicability of the case and how you want the court to actually understand your argument. And it must be, what is mostly important, must be supported by the law, and it must be supported by sound case law as well. Thank you very much, Ahmed. That is the...
Romeo, sorry, there's a question from Laura. Laura?
Good day, Judge.
Yes,
I just wanted to know if your approach to the heads of arguments would be different in an appeal.
Yes. Yeah, correct, Laura. In the appeal, obviously, it will not be the same as when you are just starting out the matter. They will be different. And as I've set out to you, there are different guidelines of heads of arguments that you can look at that deals with appeal and the requirements of those heads of arguments and the structure that it needs to follow, Laura.
Okay, thank you.
Yes.
So, Judge, if I can just ask a further question in terms of the heads of argument. Often I've seen in my opponent's heads of argument, and I may have also fallen to the error, where one would find the drafter setting out their whole chronological background that's already contained in the founding affidavit and commented on in the answering affidavit, for the judge to then read it again. My understanding has always been, insofar as heads of argument are concerned, is to determine what is the legal issue that the court is required to address. And thereafter, what is the applicant's view in respect of the legal issue? And what is the respondent's view on the legal issue? And then conclude, but what does the law say on that issue? And then therefore to conclude that the version that the applicant or the respondent advances, depending on who I'm acting for, is in fact the correct one.
Yeah, but thank you very much for that. There can never be an overemphasis on the issue of people that like repetitive things. I don't know whether it is being done to claim more fees. That is completely unnecessary. To actually add to that, but you'll find that there are agreed set of facts, and you'll find that when you start writing your heads of argument, you start saying, but these are the agreed facts, and these are the facts that we don't agree on. That's completely unnecessary, because all those things have been advanced on your arguments. In your heads of arguments, you have to draft what is the position of the law, what are the arguments that you are presenting for and against, and supported by the case law and the authority, and how do you want the court to actually rule in your favor against the other version of the other party that you are appearing with. So there is a whole list of chronology of the history of how the matter started, and the point where you are bringing the heads of argument. It's really not the worth on the paper that you are actually writing it on. Heads of arguments are actually that, heads of arguments. You must bring arguments on your heads and show the court why the court should go for you and not against you, given the arguments that were presented by your opponent and given the arguments that you want to present in your favor. So that is the position that has to to be followed. Thank you very much.
Romeo, there's a question, Judge, with regards to heads of arguments and the case law they contain, how much depth should we go into to assist the court? Are the main principles of the case sufficient, or does the court prefer if we go into more detail surrounding the main points?
Thank you for that question. It's important that when you summarize that, you reference your main points and the basis of your main points in support of your case. Obviously, facts of the case differ, and you might have your case going in a different direction altogether. But what is important and what needs to be emphasized there is that bring the relevant facts on your table that either support your case or against your case, and try and persuade the court that even if in this matter that the court looked at in a different way altogether, my case is different, and the submissions on the law, it is based on the following reasons, and these are the reasons why in our heads advancing that the court should look at this matter, rule in favor on that basis. The cases, you will take it that when you are appearing before the court just they know them and they know those not. So what you can do by mentioning what is relevant to your case and applying it to your facts. Thank you, Ahmed.
Are there any further questions from the participants? You can unmute your mic and ask Judge. Okay, Judge, I think that leaves us with, to bring me back again to the conclusion. The only thing that remains for us is to thank you, Romeo, for your, Judge, for your time. As I have indicated earlier, Judge, you are indeed a valued member of the South African Bar Association. Appreciation to those that have attended virtually. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. Once again, thank you, Judge, and it is always a pleasure.
Thank you, Bob.
Thank you.